Stephen Coperns, Managing Partner of Coperns Law, LLC. And today I'm excited to discuss Kingdomware Technologies, Inc. getting its day in court. That's the U.S. Supreme Court. On February 22nd, 2016, the Supreme Court heard arguments in the case of Kingdomware Technologies, Inc. versus United States. That's the big case that will decide the extent to which the VA must prioritize veteran-owned businesses in its contracting. As followers of the case are aware, a 2006 statute, which I'm going to call the VA Act for ease of reference, calls for the VA to award contracts based on competitions restricted to 2 or more SDVOSBs or VOSBs, where 2 or more such companies exist that are reasonably expected to submit offers at fair prices. However, the VA has long maintained that the VA Act doesn't apply to purchases from the Federal Supply Schedule, which is known as the FSS, or sometimes as the GSA schedule. Now, this debate, whether or not the FSS is exempt from the VA Act's Rule of 2, has made it all the way to the Supreme Court. It started there at the GAO several years ago. Now it's all the way in front of the U.S. Supreme Court. On February 22nd, I was there in the courtroom in the Supreme Court, watching counsel for Kingdomware and counsel for the government do their best to answer questions from the Supreme Court justices. Here are my impressions of what I saw. Now, for folks like me who are strongly supporting Kingdomware in this matter, there's some good news. First, at least 2 of the justices signaled that they read the 2006 VA Act as establishing a mandatory SDVOSB and VOSB preference. After a lengthy question to Kingdomware's counsel, a gentleman named Thomas Saunders, Justice Stephen Breyer stated that he didn't see an exception for the FSS in the statute. Justice Elena Kagan made similar comments later in the day. The justices pressed the government's counsel, a gentleman named Zachary Tripp, who argued that other set-aside statutes, like those for the 8A and Hub Zones program, do not apply to FSS buys. So Mr. Tripp is trying to draw a parallel between these other statutes and the VA Act. Now, in response, Mr. Saunders reminded the court that the VA Act was passed by Congress precisely because the discretionary set-asides were not enough to cause the VA to maximize its procurements from veteran-owned businesses. Some of the justices also seemed skeptical of the VA's argument that an order isn't a contract, it's an order under the Federal Supply Schedule. And the VA's arguing that that's not a contract, and then therefore the Rule of 2, and start getting into some statutory stuff here, but the Rule of 2 talks about contracts. The government's argument is that the Rule of 2 doesn't talk about orders, so it doesn't apply to FSS orders. But Mr. Tripp conceded that an order ordinarily falls within the definition of a contract, and that's true. If you look up FAR 2.101, the definition of a contract, it expressly includes an order. So Mr. Tripp didn't have much choice but to concede that, for the most part, an order is a contract. Then Justice Kagan asked why that concession that Mr. Tripp just made doesn't answer the case. Now, in my view, Mr. Tripp didn't offer a particularly compelling response to Justice Kagan's comment. For his part, Mr. Tripp focused primarily on policy-based arguments. He argued that it would be cumbersome and difficult for the VA to apply the Rule of 2 in every setting. He argued that forcing the VA to follow the Rule of 2 could harm the VA's mission. Now, again, in my view, Mr. Tripp went to the policy well a little too often, even in situations where the questions that justices were asking weren't about policy. As Mr. Saunders pointed out in his rebuttal, it is up to Congress, not the court, to make policy. That said, Mr. Tripp's policy arguments didn't seem to be falling entirely on deaf ears. Some of the justices seemed concerned that ruling against the government could create unnecessary and perhaps unintended burdens for the VA. Now, the VA has been making these policy-based arguments for a while, and I've long thought that these arguments are overblown. But for an audience of justices who aren't experts in the government contracting field, these arguments could potentially be compelling. Now, speaking of expertise, let's be perfectly clear. The Supreme Court is populated with some of the brightest legal minds in this country. That said, the justices cannot be experts in every area of the law, and that is particularly the case in a complex area of the law like government contracting, which is not only complex, but is an area of the law which is seldom the subject of a Supreme Court case, so not a whole lot of experience at the Supreme Court level with government contracting law. In my view, some of the justices' lack of expertise and experience in this field was on display in this February 22nd hearing. For example, 1 or 2 of the justices seemed confused about the preferences that are created under the VA Act. They seem to believe that those preferences apply to individual veterans rather than the limited pool of VA-verified SDVOSBs and VOSBs. Some of the justices also seem confused about what the VetBiz database is, what it contains, what NAICS codes are, SAM profiles, kind of the underpinnings of government contract law and formation. Other justices wondered whether ruling in Kingdomware's favor would mean that 100% of VA contracts would ultimately go to SDVOSBs and VOSBs, to the exclusion of everybody else. In fact, Justice Breyer said he thought it was surprising that the VA would adopt a statute that could lead to 100% of contracts going to veteran-owned businesses. But on this point, I think the answer for those who know the field well is pretty clearly no. After all, the FAR has contained a similar mandatory Rule of Two preference for small business for decades now. Decades. And even though this pool of small businesses is much, much larger than the pool of verified SDVOSBs and VOSBs, the government historically has had trouble meeting its modest 23% small business goal. The government's met that in the last couple of years, but historically has been somewhere in the 21 to 25% range of all contracts to small businesses, even with a mandatory Rule of Two preference. And I expect that you'd see similar numbers perhaps at the VA, certainly not 100%. Now, while I certainly don't expect the justices to become government contracting experts overnight, I am a little concerned that the government's policy arguments may be more compelling to those without a fuller understanding of this field of law. Finally, the big question folks are asking me, what happens now? Well, the Supreme Court is likely to issue a decision by the end of its current term in June 2016. The decision, of course, could be a win for Kingdomware or a win for the VA. Because of Justice Antonin Scalia's recent passing, it's also possible that the court could deadlock in a 4-4 tie. If a tie occurs, the case could be held over for re-argument when a new justice joins the court, which could be, this year could be 2017. Alternatively, the court could allow the ruling of the Federal Circuit to stand. If so, that would be a loss for Kingdomware, because Kingdomware lost by a vote of 2-1 at the Federal Circuit. Finally, Justice Ruth Bader Ginsburg raised the possibility of yet another outcome. During the oral argument, Justice Ginsburg expressed concern that the government's current legal theory, and I referred to that earlier, the theory currently is that an order is not a contract. But Justice Ginsburg is concerned that that was not the legal theory that the government used and actually won on at the Federal Circuit and below at the Court of Federal Claims. Justice Ginsburg seemed hesitant about the Supreme Court being the first and only court to weigh in on this new theory of the government's, without the benefit of a lower court record for the justices to review. One or two of the other justices seemed to pick up on the same concern after Justice Ginsburg had expressed it. Now, it's possible, based on this particular concern, that the court could send the case back to the lower courts for consideration of the government's legal argument. If so, June wouldn't be the end of the line for this Kingdomware case after all. We'll all just have to wait and see.